Okay, so this article is Article 10 of Domestic Relations Law, Action for Divorce. And the first thing it says is that an action for divorce may be maintained by husband or wife. So they have not amended this to say spouse, even though New York does have marriage. Equality for, so just keep in mind, still says husband and wife as of 2018. Okay. Now it's the grounds, and the grounds are, okay, so I'm going to do the list quickly, and then I'm going to do it in detail based on what it actually says in the statute. So the quick list is 1, cruel and inhuman treatment. 2, abandonment of plaintiff for 1 or more years. 3, incarceration for 3 or more years. 4, adultery. 5, judgment of separation or decree of separation for 1 year. 6, written agreement of separation entitled to a deed to be recorded. And 7, the marriage has irretrievably broken down for a period of at least 6 months prior to the filing of the action. Now, let's do the full statutory list. 1, cruel and inhuman treatment. 2, abandonment for 1 or more years. 3, confinement in prison for 3 or more years. 4 is adultery after the marriage take place. So this is not like adultery in this article is not like you hooked up with, you just like kissed somebody else or you had an emotional affair with somebody else. It's got to be actual those things, okay? 5, they have lived separate and apart pursuant to a judgment or decree of separation for a period of at least 1 year. And the plaintiff has to plead that he's done or she has done everything in the agreement. Substantially performed all the terms of the agreement for 1 or more years after the granting of such decree or judgment. 6, the husband and wife have lived separate and apart pursuant to a written agreement of separation subscribed by the parties and acknowledged or approved in the form required to entitle a deed to be recorded for a period of 1 or more years after the execution of such agreement, and satisfactory proof has been submitted by the plaintiff that they have substantially performed all the terms and conditions in the agreement. Such agreement shall be filed in the county clerk's office where either party resides. In lieu of filing agreement, either they can file a memorandum, has to be subscribed in the same way, and has to be filed in the county clerk's office where either party resides. It has to contain the following information: the date of the marriage, the names and addresses of the parties, the date of the agreement of separation, and the date of this subscription and acknowledgement or proof of such agreement of separation. And then 7 is the 6 months thing, provided that one party has so stated under oath. No judgment of divorce shall be granted under this section unless and until the economic issues of ED of marital property. So ED is equitable distribution, and I'm going to abbreviate that a lot. It's not erectile. And then it says, no judgment in divorce shall be granted on this subdivision unless and until the economic issues of equitable distribution of marital property, the payment or waiver of spousal support, the payment of child support, payment of counsel and expert fees have been decided, as well as custody and visitation with any infant children are resolved or determined by court and incorporated into judgment and divorce. Okay, so this is Domestic Relations Law, Article 10, Grounds for Divorce, continued. Shot. 1, the cruel and inhuman treatment of the plaintiff by the defendant, such that the conduct of the defendant so endangers the physical or mental well-being of the plaintiff as to render it unsafe or improper for the plaintiff to cohabit with the defendant. 2, the abandonment of the plaintiff by defendant for a period of 1 or more years. 3. Confinement of defendant in prison for 3 or more consecutive years after marriage takes place. 4. Commission of an act of adultery for the purpose of Article 10, 11, and 11-A is defined as the commission of an act of sexual intercourse, oral sexual conduct, or anal sexual conduct voluntarily performed by defendant with a person other than the plaintiff. If you want to get a divorce based on grounds of adultery, you have a statute of limitations. You have to commence it within 5 years. If there was forgiveness either by voluntary cohabitation with the person after finding out, or actually express forgiveness, then they wouldn't be entitled to a divorce under this section. So this is not like adultery in this article is not like you just like kissed somebody else or you had an emotional affair with somebody else. Now, the ironic thing is that everyone just gets it under, they either get it under one or two things. It's either under the Cruel and Inhuman Treatment, and that's basically about the Violence Against Women Act or whatever. That's an immigration thing, I think. Everybody else that gets a divorce does it pursuant to subsection 7, which is the irretrievable breakdown for at least 6 months prior to the filing. Provided that one party has so stated under oath. Provided that one party has so stated under oath. In subsection 7, there is no statute of limitations on it, of the action, because there's basically no cause of action. No cause of action. You just need that, it'd be 6 months immediately preceding the filing immediately. Just hope I remember that in case they try to get sneaky.